Okay. All right. Well, welcome everybody. Thanks for coming to this session of our program today. Oh, hello. Just very briefly, by way of introduction, my name is Jared Ficklin. I'm a lecturer here at the University of Liverpool. I'm co-director of the Liverpool Law Clinic. So mostly what I do is work in the clinic on refugee and statelessness cases and the modules that we have here at the university for the third year students. Today we're hosting this session on criminal law and accountability. We're going to start with Dhiyathad Prateeppornnarong from the University of Birmingham, who's going to talk about independence in the police complaints system, followed by Val Swain from the University of East Anglia, talking about police data gathering practices and the need for a clear basis in law for that. And finally, Michelle Coleman from Middlesex University, restoring the presumption of innocence during investigations. So I'm going to turn it over to Dhiyathad. I just get to hand the microphone over there.
Thank you. Thank you. And okay, good morning, everybody. My name is Dhiyathad. I'm from University of Birmingham. Yeah. Today, my presentation is about the systems for handling police complaints in Thailand, as well as in England and Wales. This is not a comparative study, but just some element of comparison between Thailand and England and Wales. And as shown on the slide, my presentation title is about the element of independence in the police complaint system. But actually, what I really want to focus here are two important points, which is, of course, the element of independence in the complaint system. And the second point is about the power of the complaints body to address complaints effectively. Before we go any further, I just want to mention a little bit why independence is so important here, because in the past 3-4 decades, or maybe in some other jurisdictions, maybe longer than that, it's been proven in many parts of the world, including the English-speaking jurisdictions, as well as in Thailand, that the internal disciplinary mechanism of the police force failed to instill public confidence in terms of handling police complaints fairly and effectively. And there is a growing trend for independence around the world, and actually, especially in Thailand as well. Right. I'd like to begin by a brief introduction into the complaint system in Thailand and in England and Wales. I said in England and Wales because in Scotland and Northern Ireland, we've got a different system. Yeah, right. In Thailand, the complaint system that deal with the police is fragmented, meaning that there is no any single organization that deals with this problem exclusively. Yeah, but one of the most important watchdog bodies is the National Human Rights Commission, or in short, the NHRC. The NHRC was founded by the Constitution, the Thai Constitution in 1997, came into operation in 2001. Here in the England and Wales, you have the Independent Police Complaints Commission, founded by the Police Reform Act in 2002 and started functioning in 2004. Next, I'd like to move on to the institutional arrangements of these bodies. First, let me start with the NHRC. The NHRC, according to the Thai Constitution, it is an independent body. And in terms of securing the independence in the NHRC, some of the key credentials at the NHRC Commissioner is important to talk about. First, they cannot be involved with politics while they are applying for the job or while they are serving as the commissioners. As some of you may know, that Thailand is in the political crisis for like maybe 20 years. So we really focus on the political issue. And the second is the commissioner cannot be employed by the government or by the private company. Now we move on to the IPCC. The IPCC is independent police watchdog, founded by the Police Reform Act in 2002. And one of the most crucial facts about the credentials as the IPCC commissioner is that those who are former police officer or having police backgrounds cannot serve as the IPCC commissioner. But this doesn't apply to the other employees of the IPCC, like the investigators. Next, I'm going to talk a little bit about the statutory responsibility. Actually, there are many responsibilities of this body, but Most important one, of course, is that both of them are capable of dealing with police complaints. And after the investigation, they are similarly capable of suggesting disciplinary measures or actually any other recommendation to the police force. Now we are moving on to one of the key topics of this presentation, which is about the element of independence. We all know now that the NHRC and the IPCC are independent of the police, and actually they are not subject to hierarchical orders of the government. So in practice, they are independent of the government as well. But we need to look into the matters around the operational independence as well. And to do that, it is worth dealing with the theory of regulatory capture as the conceptual framework of the operational independence. The capture theory explains, as shown on the slide, a poor performance in regulations with reference to techniques by which the group being regulated subverts the impartiality and zealousness of the regulator. To put it simply, this means the theory explains the situation where the regulatory body ends up being manipulated by the regulated agency. And how can this be applied to the police complaints body, or indeed applied to the NHRC and the IPCC? There are so many ways that it can happen, but one of the ways is the infiltration of the people who have institutional or cultural connections with the regulated body, or to put it simply, those who have cozy relationship with the police force. Why do the institutional connections matter in this area? Because, like for example, according to Prinsley and Rogan, they underline that a typical traditional police organization will feature an extremely high level of group loyalty. And this makes it difficult for them to testify against other police. To put it simply, this means like they think of them like there's the same group, and they have some sort of special relationship between police themselves that make it difficult for them to testify or to act against other police officers. And in Thailand, the NHRC is the people who have police backgrounds are not banned from being appointed as the NHRC commissioner. And the fact shows that many posts in the watchdog bodies in Thailand, including the NHRC, but in other watchdog bodies as well, are filled by ex-police. So many ex-police are serving as the independent commission in Thailand. And during my research fieldwork, I met so many complainants, police complainants, who expressed their skeptical views on the impartiality of the commissioners or the investigators who have police backgrounds. Like one of those mentioned to me that he met one of the NHRC commissioners who have police background, and this particular commissioner told him that his complaint was skimmed through preliminarily, and then it seems to him that the officer complained against seems to be innocent. And that to him mean like this particular commissioner completely biased, because he said something like that even before the investigation has started. In England and Wales, the institutional connection is a controversial issue as well, because as a previous study has shown that even though some of the ex-police who are now working in the IPCC or in other police complaints body around the UK can work really well in terms of handling police complaints, but there are some of them who cannot detach from police mindset, who still be influenced by police culture, something like that, and which it make it difficult or become negative in terms of handling the complaints impartially. And this is the institutional connection is getting even worse, because nowadays, for example, as of 2014, the statistics shows that 9 out of 14 senior investigators in the IPCC have police backgrounds, and this raised public concern over the impartiality and the effectiveness of the handling of police complaints in England and Wales as well. Now I'm moving on to the second point, which is about the power to enforce proposed disciplinary measures. Actually, there are so many problems around the power of the complaints body in England and Wales and in Thailand as well. But for the benefit of time, I chose one of the most controversial one, which is the power to enforce the measures. The NHRC is capable of suggesting disciplinary measures. However, it is incapable of enforcing those measures. So what they can do is, in terms of making sure that the action will be taken, is that they need to seek cooperation or assistance from the Prime Minister or the Parliament to compel the police to implement those measures. But even if these inquiry cases on the slide confirm that even if the police accept the NHRC measures, however, they are not obliged by them. These cases show that when the police accepted the measures, they later on decided to re-investigate the case and produce the investigation reports that were contradictory to the NHRC findings. That means ultimately the officer complaints against can go free. When it comes to the IPCC is a little bit more powerful than the NHRC in Thailand. At least the IPCC has the power to direct the police to enforce the disciplinary measures. However, according to the PRA or the Police Reform Act, after the IPCC investigation, there needs to be a disciplinary panel being appointed to determine the IPCC investigation and its outcomes. And this means that the IPCC investigation can be subject to changes. The result of that can be subject to changes. And actually, the IPCC explained that in some circumstances, the disciplinary panel just concluded the case that contradictory to what the IPCC suggests from the outset. And that means in some cases, the officer complained against go free as well. Then I'm going to move on to the my proposal to solution, but before that, just focus to the argument about the ex-police involvement. From the perspective of the complaints body, they will that actually in Thailand as well, and the IPCC, they agree that ex-police are valuable asset to the complaint system because they have investigative skills, they are experienced, they can help in terms of handling police complaints very effectively. However, it is arguable that these skills are not unique to conventional police. This can be practiced, this can be imparted to other people as well. And if we think about the government departments nowadays, there is an increasing trend that they use the civilian investigators as well. So that means civilian investigators can investigate the case as well. This leads me to suggest that to secure operational independence, for the NHRC in Thailand in particular, I would like to suggest that ex-police shouldn't be made the NHRC commissioner to secure the to instill public confidence that the NHRC is really independent. And for the NHRC and the IPCC in general, I think there needs to be a limit on the proportion of ex-police investigators, not just recruiting ex-police into the organization more and more. And then they need to focus that ex-police investigators who are already there should act in an advisory capacity only, in my opinion, because the advisory capacity will help, and link to the last point, will help to place the importance on training civilian investigators as well. Next, I'm moving on to the argument over the power to enforce proposed measures. From the perspective of the complaints body, the IPCC and the NHRC, they will that they shouldn't have the power to enforce measures or shouldn't be the decision makers in terms of disciplinary action because they are investigative body. However, I'd like to argue that even though the investigation is substantiated, But if there is no guarantee that action will be taken after the substantiation of complaints, it means very little for the complainants, because this means that the problems may left unresolved, and there is no point that they are coming and turning to the complaints body in the first place if there is nothing can be done. So I propose also that the NHRC and the IPCC should be assigned a role to make decision on disciplinary action. However, it is legitimate to have a debate that this decision can be subject to judicial review or any other independent bodies. Again, this is the end of my presentation. Thank you for listening.
Thank you very much, Dhiyathad.
Thank you.
We'll save questions to the end, I think. So next we have Val Swain from the University of East Anglia.
Can I use this microphone? Yeah. Help. Okay, hello everyone. I'm Val Swain. I'm from the University of East Anglia, and as you can see, my interest is in police surveillance, particularly of what you may call risk groups, protesters, football fans, and other such activities. And those of you who are not surveillance scholars, or perhaps those of you that are, would automatically assume the word surveillance with the monitoring of more private activities, of monitoring, interception of phone calls and some bulk data gathering under PRISM strategies, etc. But actually what I'm looking at is a far more mundane, more day-to-day level of data gathering. Overt forms of surveillance include, but are not restricted to, photography and filming. They cover a whole range of activities, from your standard note-taking to CCTV. And CCTV, in connection with CCTV, it covers all the background, back room functions, the analysis, the facial recognition, the use of automated number plate readers, and the databases that those are connected to. And it also covers the monitoring of public forms of social media, particularly Twitter. I don't know if you follow the news, but Jenny Jones, the Green Party, has famously been found that her tweets have been both monitored and retained by the Metropolitan Police because of her political activity. So in terms of regulating this activity, RIPA, the Regulation of Investigatory Powers Act 2000, is the key statute for regulating surveillance. And it covers the surveillance of public spaces, but it only covers the surveillance of public spaces where that is covert. And this is their definition of covert. It's not the clearest definition in the world, and it creates huge problems in interpreting what this actually means. I mean, we could spend some time debating what it means to carry out something in a manner calculated to ensure. It is a very obtuse definition, but what is clear from this is that the distinction between what is covert and what is overt is to do with the awareness and visibility of that surveillance. And this matters because where surveillance is covert, there is a whole regulatory, statutory regime about that, which may be criticised for not being quite substantial enough, but is still there. and requires statutory authorisation procedures and some measure of independent oversight. Whereas, of course, if surveillance is overt, that doesn't apply, and there is a much, much greater degree of discretion available to law enforcement bodies in carrying out such surveillance. Of course, there are reasons for this. This is an extract from a European Court of Human Rights case, and it illustrates what is a received view that actually the secrecy of state surveillance, even in a public place, the fact that it is hidden, is in itself a threat to privacy, because we cannot see that it takes place. We cannot hold governments to account for it. We cannot know whether governments or states are acting in a way that is arbitrary or excessive. So secrecy carries a threat. The other side of that, then, is the suggestion that visibility somehow is a safeguard, is a protection against that threat. The argument that because we can see surveillance, we can take actions to prevent our privacy. We may be able to avoid the surveillance altogether. We can ensure that our inner secrets are not put on display. We can, to some extent, control the amount of information that is out there available to other people to see. So visibility is important. And this has been reflected in a number of recent court judgments, this one relating to police photography of protests. And here it was a great deal of weight was placed on the fact that the surveillance was visible and the person under surveillance could see that they were being filmed, and they could see that they were being filmed by a police officer. Likewise, in this case, the case of Katz, John Katz was a 85-year-old campaigner who discovered evidence that he had been, police had been monitoring overtly his attendance at protests for 4 years and collated details on at least 55 demonstrations that he was at. And once again, the fact that this surveillance was not covert, it wasn't hidden, was a justification for this, for such interference that there was in his private life, was considered minor and trivial, easily justified by the need to prevent crime and keep order. But in my view, there are significant flaws in this argument. Some of those relate to the failure for any of these arguments to take into account Articles 10 and 11, other than privacy, the right to freedom of expression and assembly. Events such as protest and participants in protest activity put a great deal of their personal information in the public realm, particularly, most obviously, their political affiliations and opinions, but also their associations and friendships. People take part in such things, often with other groups and with their contacts. The collection and collation of such material actually is a very powerful surveillance mechanism. And additionally, there has been considerable complaints from protesters and others that surveillance of this type actually is quite intimidating. It is not necessarily very pleasant to be the focus of that sort of police attention. And there has been very strong suggestions that this operates a chilling effect, a deterrent on people's ability to take part in protest. But there is a wider question, I think, which is to do with this idea of visibility and the question of what level of visibility, what level of awareness is necessary for these supposed safeguards, these protections against arbitrary state action to come into play. On the left-hand side, the image there is very different from the previous image of the police photographer. It is the same, but perhaps the way that those photographers are deployed has a significant impact on the extent to which their targets are aware of what is going on. The second picture is obviously a camera, a camera-enabled, a CCTV-enabled vehicle, and yet that's obvious, yes. What's not very obvious is that this is a police camera-controlled CCTV-enabled vehicle. And going back to the quote earlier on, one of the important factors here in the fact that it is overt surveillance is that you could see who was carrying out the surveillance. Well, here, I don't think you can necessarily see who's carrying out the surveillance. There are requirements under the Data Protection Act for data controllers to be identifiable. And I think here the Metropolitan Police feel that they got around that with a 6-inch plate that was attached to the back of this van, which stated that it was a Metropolitan Police overt operations vehicle. But if you were taking part in a protest and you were going past this, or this was parked behind police vans, you would have a great deal of difficulty being aware of exactly what was going on here. And the third photograph is a police-operated CCTV camera that was parked in an adjacent field to an environmental protest. And here there are similar issues of visibility, and also a question, I think, the extent to which the targets would be aware of the capability of such systems. This was a live feed it was an entirely peaceful demonstration. This was a live feed to a remote police control centre. And the capability of this camera was quite extraordinary. Over some distance, it captured very high definition close-up images at a level where you would consider it would be highly unlikely for those people being the target of such surveillance to have any awareness that that was happening at that time. Problems become even worse, I think, in terms of visibility of social media. Again, we're back to Baroness Jenny Jones. In the case of Katz, in which Jenny Jones also intervened, it was Lord Sumption almost dismissed this idea that there wasn't awareness that such surveillance was taking place. Well, of course, there are these units. Of course, they gather this information. This is well known to anybody who seeks to inquire. But there are clearly some problems with that too. As the Chief Surveillance Commissioner has pointed out, knowing something might be happening is very different to knowing it is happening. And also, Lord Sumption seems to have an extremely generous idea of the amount of information that is in the public realm about these activities. Actually, what's happened to Jenny Jones was only released, only became known as a result of some very long, some very dedicated investigative journalism and a great deal of effort on the part of a number of activists, including John Katz himself. So, yes, it is not actually necessarily well known exactly what is going on. So to conclude, visibility is important. It is not the only consideration here, but I do think that it is important. But if we are going to use visibility as a determining factor in how a surveillance operation, how a surveillance practice is going to be regulated, we need to have a much greater grasp of what that actually means. In my view, visibility is an important way of accountability. It's an important part of holding that system to account. But any visibility that we rely on must be visibility of the entire surveillance process, of the collection and retention and analysis and dissemination of intelligence material, not just of one part of it, which may be whether or not you can actually see a camera or not. So yes, I think that's me.
Thanks very much, Val. And now
Sure,
we
yeah.
have Michelle Coleman from Middlesex University. About presumption of innocence during investigations, and after that we'll take some questions. We're doing well for time, so
Hi, thank you. I'd like to thank the Organizing Committee for me today. I'm Michelle Coleman. I'm from Middlesex University. I'm currently writing my PhD thesis on the presumption of innocence and trying to find a definition, encompassing definition using case law and theory. And the presentation I have today is an idea that's kind of come out of that in combining theory and also hard law and case law, whether or not the presumption of innocence can be used as a tool in different stages of criminal justice, and today focusing on the investigations. My talk is focusing on US law, partly because it's the jurisdiction I'm most comfortable in, and also partly because there have been so many issues of police violence and against individuals during the investigation stage. So, all right. First, the first important point is that the presumption of innocence is a universal human right. The presumption of innocence is in, here's, well, a list of examples of treaties that the presumption of innocence is in, but it's also in others, the ICC statute that's recognized as customary law by the International Commission of the Red Cross, and presently all countries recognize the presumption of innocence and at least give lip service to it in their law in one way or another, whether it's their constitution, specific law, or case law. And while this is all true, the presumption of innocence is basically entirely undefined in any jurisdiction. Most of the conventions and treaties where it's spoken about have nothing in their foundational documents or travaux préparatoires discussing what they mean by the presumption of innocence, what they mean by innocence, when it attaches, what the scope is, or who is the duty holder in this right for the presumption of innocence, and in fact, who is the right holder. So it's wide open, and this is true in domestic law as well, particularly in the United States, but also in other countries. So to turn to the US and the basis of the presumption of innocence there, it's not in our Constitution. It's not a formally written federal law. However, there is constitutional basis in the 5th, 6th, and 14th Amendments, as was decided in the state of Coffin versus the United States. Coffin is the first first federal case that establishes the presumption of innocence, and it's also one of very, very few federal cases that deal with presumption of innocence at all. The U.S., like most criminal jurisdictions, doesn't regularly deal with presumption of innocence or give us any insight through case law as to what it might mean, partially because they focus more on more concrete procedural or due process rights. So the constitutional basis through the 5th, 6th, and 14th Amendments, just to give you an idea of what those amendments are, is the 5th is the right to not incriminate yourself, the right to have indictments, and the right to due process and double jeopardy, or against double jeopardy generally. Number 6, it gives more criminal defense rights such as speedy trial, the right to defense counsel, and the right to jury. And number 14 is the amendment that makes these amendments also applicable to the states. So it kind of makes these rights applicable to everyone in the US, whether federal or state. And then the presumption is actually created by case law. So the interesting thing about Coffin is that it states that it's not specific as to the level of proof that is needed to overcome the presumption of innocence, nor when the presumption of innocence attaches. Most of Coffin deals with the right to have a grand jury and to have that grand jury be independent. So it kind of implies that the presumption of innocence could come into force before the actual trial of the individual. And in fact, in many cases, we know that the presumption of innocence is at least considered pre-trial, specifically in pretrial detention issues and in search and seizure instances. In a number of places, but specifically in the US, pretrial detention often refers to the right to the presumption of innocence, that, oh, if you're detained pretrial, it has nothing to do, it doesn't overcome your presumption of innocence. If there are factors dealing with why you could be detained pretrial, those factors may include also the presumption of innocence. And in fact, the federal pretrial detention guidelines in the US state that it's specifically contemplated as not being overturned by any sort of pretrial detention decision. And another place where we see it is in search and seizure, and particularly in stop and frisk kinds of situations. These cases are mostly litigated on the right to privacy. However, there are many, many arguments that stopping people and frisking them on the street, such as what has been happening in New York, violates the presumption of innocence towards individuals who are just walking around. So this kind of brings into the theory, as we'll see, but gives a good background of the presumption in the US. So the presumption of innocence, I think partially because of the lack of case law and definition, has a lot of theory, and a lot of people are trying to come up with normative definitions based on theoretical ideas. These theories range from very, very narrow definitions to very broad. An example of a very narrow one is Larry Loudon, who's an American theorist, who states that the presumption of innocence applies only at trial, only during trial, only from the fact finder toward the individual on trial, and it's only a restatement of the burden of proof. But fortunately, there are others who have a much wider view of what the presumption could mean. So Thomas Weigand gives the presumption could that states the presumption could apply when someone becomes a suspect. Weigand comes from Germany, so there's also the civil law aspect of that as well. When people become suspects, it's quite fluid, and both in civil and common law. And I think that there's potential there for someone being investigated to be deemed a suspect. Andrew Ashworth states that the presumption is from the state toward the individual and should apply at all stages prior to conviction. He limits it quite a bit to the criminal law process and the official processes of criminal law, but again, this kind of opens it up to the possibility of, well, all stages. That could be right now. We're not being suspected of anything, so kind of it opens it up a bit. And probably the two most broad theorists are Hockley Ho and Anthony Duff, who both argue that the presumption should apply to people, basically just ordinary, everyday people all the way through, your entire life. Hockley Ho states that it's more of an umbrella right that contains all of due process within it, whereas and limits the state against individuals, whereas Anthony Duff argues that there's even a civic presumption of innocence that we owe towards each other as individuals and citizens of the state, and that we give to each other every day on the basis of mutual trust. So when we look at the case law and the law, we see that it's broad and undefined, or has the potential to be broad, and because it's undefined. And when we look at the theory, there is a potential for almost an anything goes kind of presumption of innocence. So if we want to think of them as a combined thing, we could see that nothing in the U.S. case law or statutes prevents a pretrial or investigation presumption of innocence. And it begs the question, why not? Like, why not have it? I think that having a more active and more participatory and more in the forefront of our mind presumption could be a good thing. So if we were to combine the law and theory, we get something that looks similar to the presumption is a human right. We know that. It's overcome when the standard of proof for a particular situation is reached, and it restarts for each stage of the criminal justice process. We know that, well, it is a human right, but that the thing that overcomes the presumption is always the standard of proof being reached. In trial, if you limit it to just the trial, going to the reaching the standard of proof of beyond a reasonable doubt overcomes the presumption of innocence. And there are different standards of proof for each stage. So at an investigation, it could be reasonable suspicion or something like that, and then going up to the trial. And it must restart because if not for each stage, but for each level of government actor, because each level of government actor, each stage of the investigation or trial has a different level of proof. So if the law and the theories combine in this way, then it's open to having a more participatory presumption of innocence and a more active one. And I think that if we were to decide to look at the presumption of innocence this way, or have a more broad presumption, then we might be able to, it opens it up to be a tool for law enforcement. I think that this could result in better, more balanced investigations for a better search of truth, because if you don't go into an investigation thinking or deciding quite quickly that someone is guilty, then you're more likely to look at all sorts of other information, including exculpatory information or the potential of other suspects and things like that. And I think that this could also potentially result in a reduction in police violence or arbitrary searches against individuals, because it would force police officers to view individuals as not necessarily guilty, but potentially, at least very potentially innocent as well. And my idea for how this could be used as a tool for law enforcement could be that it could be more reinforced during, I am not a expert in police tactics or anything like that, but I think that it could be used more during training and more reinforced so that police officers and other government actors approach investigations or the criminal justice process with the presumption of innocence in mind first, rather than either just giving lip service to it or as a post-investigation, pre-trial sort of right, that's kind of related to due process. So anyway, that is my idea. Thank you very much.
All right. Thank you very much, everyone. Can I say you've done an excellent job for time. So we've got plenty of time for questions. Just to make a few comments before opening it up to the audience. It's interesting. I think we're quite lucky in this session. Some of the sessions, of course, by nature, some of the topics are quite disparate, but actually in the UK context, and I know that wasn't obviously necessarily intended by the diversity of research areas, but in the UK context, this issue about the role of police and presumption of innocence and the accountability of police, who they work for, and who the police are accountable to, is a really topical issue right now. David Cameron recently said that it's not enough to follow the law anymore. Passive law-abiding citizenship isn't good enough anymore in the UK. You now have to, he didn't say love Big Brother, but he said you now have to, in effect, publicly be part of the accepted narrative of society. And we also have this issue of surveillance, not just overt surveillance of demonstrations, but it was mentioned the Mark Kennedy case where the Metropolitan Police, an undercover officer had a relationship with someone for 7 years, deceiving her into a romantic and sexual relationship during that time. And the word that comes to mind is panopticon, that began in the UK in the 19th century in prison design, where you weren't necessarily being watched all the time, but you didn't know if you were being watched all the time. And that was all it took, because at any given moment, you might be being watched, whether by one actor or another, whether it's overtly in a park by a police officer with a camera, or it might be someone that your protest or demonstration organization has infiltrated into, and you just don't know, and the chilling effect that can have. And obviously through to the actions of the police. The riots in 2011 were initially sparked after the police shot Mark Duggan in circumstances that were potentially controversial, but not necessarily in and of themselves the kind of thing that would start nationwide riots. But then afterwards, the riots in Tottenham started because the family felt that there was no information coming from the police about what had happened. The IPCC is immediately brought in anytime someone is killed by police in the UK, but the family and the community felt that their response was completely inadequate, and that led to a great deal of anger, which overspilled into riots. So I think that these particular issues tie together really well and are really important. Also, there's the legislation coming through now, the Snoopers Charter, as it's being called, but we've got MI5 officials coming on the radio talking about how we need to have this surveillance bill because it's going to keep us all safe and allow us to prevent terrorism is always what's used, not so much animal rights activists or dare I say trade unionists or something like that. But clearly these surveillance methods are used, frankly, as much against what we would think of, well, not as terrorists anyway, if I can put it that way. Okay, so can I just throw it open for questions? I've got a few, but if anybody wants to go in there at the back.
Hi, I'm my first question is for Val Swain. Kind of along the same lines that Jerry just mentioned. With the, what I was thinking about when you showed the photo of the automobile that belonged to the police and they're carrying out surveillance is, could you speak to the issue that we don't necessarily know who they're surveilling? So there could be a lot of people walking along the street who's having their privacy invaded, and you might be an activist at a particular gathering, but you might, just be an ordinary activist, and you don't know, are they targeting just anybody, or are they targeting somebody specifically, and should we care about that when we have no idea? And maybe we want to know that so that we know how much we're being scrutinized.
Well, yes, I think that's an excellent question. One of the features of pretty much all surveillance mechanisms is that they are exceptionally broad in the data that they gather. It's I mean that's probably not the only scenario in which you would get a lot of data that would be gathered initially, and then that would be filtered down to see where out of that whether there was anything of particular interest or a particular person. In terms of CCTV, I think what tends to happen is that it is justified in terms of a general prevention narrative. So it's there in case something happens, in case there is an incident, therefore the police can then respond to that incident. And that provides the justification of why it's there and why it's taking place. And that gets them over all sorts of hurdles in terms of authorization. The question then is, once it's there and in place, how is it used? And I think this then, is what's very important about tackling visibility in surveillance beyond just the can you see the camera. The chances are that it could be used in connection with facial recognition to pick out individuals from the crowd that have a previous record or police are interested in for some reason, in which case then you're not collecting everyone's data necessarily, but you are picking out people where there may or may not be a justification for doing so. The whole prevention, it fits in with the whole prevention ethos of anticipating crime and taking action before something happens, which I think is in itself exceptionally dangerous. But in terms of visibility, it must be, I think, that if you are going to claim that this surveillance is overt and sits outside all the regulation, such as it is for covert operations, it must be that you are willing to open up that into a greater inspection of what is actually going on there and what actually is being done with that surveillance and that data. And if you as a law enforcement body are not prepared to open that up to show people what is going on, then actually that surveillance isn't overt, it's covert, and it must be regulated as such. I think that's the key thing I'm sort of looking at there.
Anyone else? Yeah.
Hi, my name is Bob Cow from Mary University of London. I have a question for the first speaker,
Dhiyathad, yes.
You mentioned limiting the proportion of ex-police officers. I'm wondering, what would be an ideal percentage, and if there's any actual we can learn from existing systems out there? Does it exist where there's in other countries where proportion of police officers are
you mean in Thailand or in England and Wales?
well, I just because that's your proposal, right? I
Yeah.
just wanted to see what you think is a good proportion, and if there's other countries besides England and Thailand that we can look at.
It's the proportion of ex-police in the police complaints body is the huge debate in England and Wales, but start from England and Wales first. There is no kind of like there is no idea how many is enough or how many is disproportionately high or something like that. But as of 2014, I think about 33% of the investigators in IPCC have police backgrounds, and that raised public concerns, especially in terms of when these people are holding important positions as senior investigators in organizations as well. But in Thailand, actually, it's the percentage is just maybe 10% for the investigators. But the point in Thailand is that the commissioner, the executives of the complaints body, some of them have police background, and that shows that the people are not trust the complaints body because you have ex-police as the executive of the commission as well. Yeah. Is that help?
Yeah. But I was just kind of wondering what maybe your personal, what would you propose as an ideal percentage?
Actually, my proposal would be I opt for the civilian complaints body, no ex-police at all, and ex-police should act in the advisory capacity only in terms of helping training the civilian investigators, because otherwise, if you have the ex-police in the organization and that ex-police dealing with your case, and people get the feeling that this is not right, and you have always have this kind of perennial issue about ex-police involved in the investigation of police complaints all the time.
Could I just ask a follow-up question to that? Is that because is the perception of police in the Complaints Commission bound up with the perception of police individually? So if there isn't trust of the police, then there isn't trust of having police on the Complaints Commission. Is that a fair corollary?
Yes, and the key issue is about the institutional connections. And in Thailand, this kind of institutional connection, we call it the patronage system, in which you help one another because you are in the same environment for so many years. You work with one another and you kind of like have a close ties with one another, and then it make you feel like really difficult to investigate your ex-colleagues or the former force or something like that. So that's the case that I'm really looking into. Yeah.
I just want to add a comment about
yes.
Dhiyathad.
Yes, yes.
There's an interesting case last year in Indonesia. One of the commissioner of National Police Commissions who come from civilian. He was investigated by the National Police Department because he exercising his authority as a National Police Commissioner to criticize National Police Department. So I think it's more interesting if you could discuss, if you could research more about how the police commissions exercising their authority, whether they could be attacked or they could be investigated by the police department.
All right. Yeah, it's a good point. It's a good point. Thank you for that.
Yes, go ahead.
Just to follow up on that conversation, I completely agree about the issues with the IPCC, but at the same time, I'm not sure that eliminating all police officers from the commission would be the most effective thing to do, because on the other hand, in recent years, we've seen a number of police whistleblowers, and I've dealt with several in my work, retired police officers who are very, very willing to come out and talk about what they perceive as misconduct in the system. And they also bring that element of knowing what some somebody on the ground ought to be doing. And so in my research, I found some of the retired whistleblowing police officers to be very effective in being able to lay out, these are the irregularities that I see, because had I been investigating that case, I wouldn't have done that, I would have done this. And so I'm wondering if there's a way to include them on the commission, but have some other, some sort of an accountability mechanism, or having them be selected by a body that can look at their actual performance.
That's why I propose that they should act in the advisory capacity to avoid the conflict, to avoid the feeling of the public concern about the impartiality of ex-police, because it's a perennial issue that people tend to believe. They have preconception. At least we need to accept that's a reality in the society, that if you know that somebody is an ex-police and dealing with your case against police, they've got something in their mind that, is it going to be impartial? Is it going to be effective? Or what can be, something like that. So I think it's a idea in terms of having the experience of ex-police being shared in the police complaints system. However, I think the important point is the capacity that those ex-police can play in the police complaint system as well.
Yes.
There's a question for Val. So I think you're very convincing in showing how the definition of overt could be much broader than we normally think it is, and that many data gathering mechanisms can count as overt despite not being especially visible. But I wonder if the overt-covert distinction is even the right one to use in determining whether, when additional oversight should be triggered. Because if one of the things you said was that visibility is important because it affords you some degree of control over the information you release to the public domain. But if someone is following you around with a camera in your face every time you leave the house, it's overt surveillance, but you don't have any control over what information you release. Well, at best, your liberty is extremely restricted as a result. So, I mean, do you have any thoughts on that? Is this distinction the right one to use at all, or is it the right one, but we just need a stricter definition of overt?
Oh gosh, you raise a very, very good point, and I think you're absolutely right that visibility only goes so far in regulating how we manage police surveillance, particularly of public scenarios and public events. I think visibility, to me, speaks to the privacy issue, but there are other issues of freedom of assembly and expression, which I think are directly, I suppose you could call it a privacy thing as well. But yes, I think you're right in that you go out, you have a camera that is thrust in your face. They follow you down the road. I mean, the case that I drew one of the quotes from, the case of Andrew Wood, he took the case to court because he was targeted for the surveillance because he came out. He was a campaign against the arms trade activist. He'd gone to an AGM to raise some questions. At that AGM, there was some protests by other people. When he came out of the AGM, he spoke briefly to one of the protesters and then went on his way. And that was the justification for him to be photographed by one of these big overt cameras. And not only did they photograph him once, they photographed him repeatedly. They followed him down the road. They tried to get his name and address. When he got on the tube, they tried to get his name and address from the Transport for London on his travel card. There are much bigger issues here then about whether or not it is merely visible. It was clearly visible, but it was extremely constraining and extremely intimidating on his ability to be involved politically and to, in that case, to carry out his actual day job. So yes, I mean, I think you're right, but searching for a conceptual framework for that, I think, is quite difficult. But certainly, yes, those are very, very important issues, and ones that are just don't seem to be getting any traction in judicial consideration, let alone in lawmaking.
Not from Lord Sumption anyway.
Definitely not from Lord Sumption,
On
no.
which we'll maybe pass no further comment. It's interesting though that how well it ties into that presumption of innocence, because if you've got people who are being monitored for what are in and of themselves completely innocent activities and completely, well, certainly not criminal activities, and then they become subject to surveillance and overtly political activities. The Green Party person whose tweets were captured as part of extremist monitoring. I mean, in terms of the presumption of innocence, what's innocent? Does that used to mean that you weren't, guilty of a crime that had been suggested that you'd been guilty of? Is that enough anymore? I mean, we have an array in the UK of civil measures to restrict people's ability to take part in anything, political activities or ASBOs. You can't go to certain areas of your community or whatever it happens to be. Areas or activities that are not in and of themselves criminal activities, but we can restrict them based on what we perceive as your character and associations and activities. And so presumption of innocence of a crime seems to lose some importance when actually what we can do quite outside of your criminal. For example, the gentleman we're talking about didn't have any sort of criminal record or anything, but he could still be targeted. He could still have a great deal of his privacy and still taken away, and instill what I would imagine is a sense of fear on the fact that you're being monitored by, the state, when you don't really know what the consequences of that are going to be ultimately, which is chilling, I think, is the word that we normally use for that. And I agree that seems to be the combination of those factors. Yes.
I'd like to comment on that. My question is actually for Michelle. I really like the idea that what you were writing can create more balanced investigation and to improve the connection between the police officer and the community and more community prosecutor itself, and also to reduce the police violence. But what I understand in the police system in the US is how there's a huge distance between police officers and the community, and a lot of racial discrimination or disproportionate. So I'm wondering, well, maybe that should happen everywhere. But I was wondering, like, how do you see the challenges the US will face to make this happen?
Yeah, thank you for that question. The presumption of innocence isn't the only, obviously it's not the only problem with police violence and targeted investigations and things like that, but and there are a lot more institutionalized issues like racism and things. I think that in terms of the possibility of using the presumption of innocence as a tool, in my experience with individuals, I used to be a criminal defense lawyer, and convincing people to start thinking about the presumption of innocence first before thinking about, oh, it's so terrible what happened to the victims, or, oh, they're guilty because they're in court or whatever, is a huge uphill battle. And I think that if you could start with at least training people in law enforcement and lawyers and people in criminal justice to think about it more in the forefront and come at it from that approach first, then it could do some good to reduce these sorts of issues and reduce biases between individuals and police. But there are other ways of doing that, like community policing and things like that get police and individuals more interaction instead of making them so distant. So
yes.
I have another question for Michelle.
Mhm.
One of the things with US criminal justice feature is the game, and Do you think that plea bargaining degrades the presumptions of innocence standard in U.S. criminal justice system?
Yeah, thank you. I think that plea bargaining can have a good function in criminal law when there aren't pressures on the defendant to plead guilty. However, in practice, there are huge pressures, and they come from all sides. They come from police, investigators, to give up more information than the defendant or the suspect normally would, or to pressure them into feeling guilty for something they may not have done. It comes from the prosecutor. It comes from even bad evidence or low amounts of evidence being collected, and overcharging. It's a huge, huge problem in the U.S. where they'll charge the maximum possible crime that they can, and then be like, oh, but you could plead guilty to this, thing for probation or something like that. And when you're faced with the choice between 25 years in jail or a year of probation, you're probably most people would probably go for it even if they didn't do anything, because the risks are huge and people get scared when they go to court. And pressures also come from criminal defense lawyers to have their clients plead guilty. Not all the time, and not every lawyer. And it certainly shouldn't be happening, but there are definitely instances of that as well. I think that while it could be used as a tool when people aren't being pressured, it does go against the presumption. It can go against the presumption of innocence as well, because even if you are the act of going to someone and saying, oh, well, you did it, you should plead guilty, I'll offer you this in exchange, is kind of assuming that they're guilty. And then especially when you start adding extra pressure for them.
Thank you. And that's a clear issue here in the UK as well, because there used to be, the right to silence in the UK criminal system. You can have, if you refuse to respond to a police interview or you just refuse to answer questions, later on at trial, if you plead not guilty and put forward an account of where you were or what you were doing, it will be held against you that you didn't say that in the first instance. So your right to remain silent only goes as far as, are you going to come up with a better story later? And if that's true, why didn't you say it at the first opportunity? Now, in criminal courts at the plea and case management hearing stage prior to trial, the defendant is expected to put forward a case statement which sets out in effect, their entire defense. So despite it still officially being the case that it's the prosecution's case to prove, and that the defense doesn't actually have to do anything because the burden is entirely on the prosecution. In fact, there are several banana skins, if I can put it that way, put in the way of the defendant with regards to that presumption of innocence, where it will be held against you if you don't have the same account from the earliest opportunity to put it forward, and you have to put it forward before your trial, or it'll be assumed that you're making it up at trial stage. So that chipping away at presumption of innocence is definitely something that criminal advocates in this country have identified as well. All right, now officially we're coming to sort of the end of our time, but any final questions that anybody wanted to ask? Well, thank you again for coming in, and thank you very much again to the panel members. I think, again, we're really lucky because we fortunately had a panel that the thread sort of ran through it in a way that maybe it won't in some of the others. So that worked out really well. Thanks again for coming, and we hope you enjoy the rest of the day.
Thank you. Well done, that was really interesting. And the IPCC is my bane of my life. You are so right.